At 9:17 in the morning Eastern Time, Washington did something it almost never does. It exposed a fault line at the very top of the constitutional structure. A rare institutional moment just unfolded at the center of federal power. The Chief Justice of the United States formally rejected the executive branch's claim that it had fully complied with an order of the Supreme Court. This was not routine clarification. It was not a scheduling notice. It was a declaration from one branch to another that compliance, as defined by the president, does not meet the court's standard. Let that land properly. The head of the judicial branch publicly contradicted the President of the United States on whether a Supreme Court order had been obeyed. Within minutes, President Donald Trump responded in public remarks accusing the court of carrying out a judicial coup. That phrase matters. It has no clear precedent in formal clashes between the executive and the judiciary at this level. It reframes a legal disagreement as an institutional seizure of authority. Here is where you need to understand the gravity. This is not about policy disagreement, not about messaging. The question now is structural. Who has the final authority to certify compliance with a Supreme Court order? An unusual legal act just occurred. Acting on behalf of the court, Chief Justice John Roberts issued written confirmation that the compliance described by the White House does not satisfy the standard set forth in the ruling. That language is precise. It signals not confusion, but insufficiency. This is where the event becomes systemic. Because once the court declares non-compliance mechanisms activate, the full context of the underlying dispute has not been made public in detail. According to official filings, the Supreme Court previously ordered the executive branch to perform a specific obligation tied to a controversial executive order. The White House subsequently submitted documentation asserting it had substantially complied. That phrasing was deliberate. It suggested good faith adherence without conceding the court's interpretation. This morning, that argument was rejected. The confirmation came directly from the office of Chief Justice John Roberts, not from a lower court clerk, not from an unsigned procedural note, from the head of the judicial branch under Article 3 of the Constitution. And this is critical that rejection opens the door to enforcement review through the federal court system below the Supreme Court. If the High Court determines that its mandate has not been met, lower federal courts can be asked to evaluate remedies. That is not theoretical. That is how institutional enforcement works. Pause here, because this is not normal. The central power actor in this moment is the Chief Justice of the United States. Under Article 3, the Chief Justice presides over the Supreme Court, coordinates its institutional voice, and defines the scope of its rulings. He does not command troops. He does not control budgets, but he determines what the law requires. His specific legal authorities matter now. He presides over the Supreme Court's proceedings. He helps shape and announce the court's institutional response. He determines how a ruling applies and whether compliance meets the articulated standard. If Chief Justice John Roberts were to clarify tomorrow that the executive branch's actions are acceptable, the temperature would drop instantly. The enforcement track would stall. But if his position holds, if the court maintains that compliance has not occurred, the next stage is not debate. It is procedure, possibly coercive procedure. And that is where this shifts from disagreement to stress test. Conflicts between the executive and the judiciary are not new in American history. Presidents have criticized courts before. Courts have constrained presidents before. But a Chief Justice directly rejecting a sitting president's formal compliance claim, in this way there is no clear precedent. The scale of power involved could not be higher. On one side, the President of the United States vested with executive authority under Article 2. On the other, the Supreme Court vested with judicial authority under Article 3. This is what constitutional scholars describe as a stress point, a moment when the written framework must prove it can function under pressure. Checks and balances are elegant on paper. They are harder in motion. And here is the layer most people are missing. If one branch claims it has complied and another branch formally declares it has not, the dispute is no longer abstract. It becomes operational. It demands an answer within the machinery of government. A direct collision between the executive and judicial branches has begun. The issue is no longer who is correct on policy. The issue is who determines compliance in a system built on divided power. Because if the court says the order was not followed and the president says it was, the next move will not be rhetorical. It will be institutional. Now we move from declaration to sequence. Because in Washington, once a branch draws a line, procedure begins to tighten. Step 1. The Supreme Court issued an order directing the executive branch to carry out a specific obligation tied to a controversial executive action. The language, according to filings, was mandatory, not advisory, not symbolic. Step 2. The White House announced that it had complied. The wording was careful. It asserted fulfillment. It framed the obligation as complete. Step 3. The Office of Chief Justice John Roberts rejected that assertion. Not privately, formally, in writing. Step 4 is where the pressure builds. The matter can move into the federal court system below the Supreme Court for consideration of enforcement measures. That is not escalation by rhetoric. That is escalation by design. Let me say this clearly. When the Supreme Court signals non-compliance, it does not debate endlessly. It turns to mechanisms. At the center of this tightening circle sits the United States Department of Justice. The department now stands between two imperatives. It must defend the legal position of President Donald Trump, and it must uphold the integrity of the judicial system it represents in court. Those obligations can align, or they can collide. If a lower federal court issues a specific enforcement order, the machinery could involve the United States Marshals Service. That service operates within the Department of Justice. Yet when executing court orders, it acts under judicial supervision. This is where lines blur in practice. Think about that structure. An executive agency potentially carrying out an order that challenges an executive claim of compliance. That is not theoretical tension. That is operational tension. And the procedural doors are narrowing. Appeal. There is almost no higher venue beyond the Supreme Court itself. Back-channel negotiation. No visible signal of that pathway. Delay. Possible but finite. Here is the institutional reality most observers underestimate. Once enforcement becomes active, discretion shrinks. Now look at the response web forming around this clash. The White House has responded by stating that the court is exceeding its authority. That language reframes the issue as judicial overreach rather than executive resistance. The Department of Justice has requested additional time to clarify the standard of compliance. That move is procedural. It buys space. It does not resolve the underlying question. Meanwhile, some congressional leaders are reportedly considering emergency hearings. Oversight enters the frame, not to settle compliance directly, but to shape the political and institutional environment around it. This is where the constitutional system shows itself in motion. Checks and balances are not a slogan. They are friction. But friction generates heat. The legal limits now under examination are fundamental. Can the court supervise in granular detail the manner in which the executive implements its orders, or does the president retain interpretive authority over how to satisfy judicial mandates within executive operations? That is the hinge. Because if the judiciary defines both the rule and the method of compliance, executive discretion narrows sharply. If the executive defines the method unilaterally, judicial authority risks dilution. This is not an abstract seminar debate. It is unfolding in real time. Let us reset the frame. Article 2 vests executive power in the president. Article 3 vests judicial power in the courts. The Constitution does not provide a flowchart for this exact standoff. There is no clear precedent for a Chief Justice publicly rejecting a president's formal compliance claim in this way. Historical tensions exist. But this configuration, written rejection, immediate presidential accusation, potential enforcement, lacks a direct analog. And here is the unanswered question that matters most. If the executive branch continues to assert compliance and the court continues to reject that assertion, who acts as the practical referee? Courts do not command divisions. Presidents do not write final judicial opinions. The enforcement of a Supreme Court order ultimately depends on institutional cooperation across branches. If that cooperation fractures, the system enters unfamiliar terrain. Now consider what we are watching in the coming days. First, will a lower federal court issue a specific enforcement directive that would translate the Supreme Court's rejection into an actionable order? Second, will the Department of Justice adjust its position? A subtle shift in argument could signal movement toward accommodation. A hardened stance could signal escalation. Third, will Congress move from contemplation to action? Emergency hearings, resolutions, or public statements can alter political incentives without directly resolving the legal question. Deadlines may be set within days. Once a compliance deadline is fixed, ambiguity compresses. And there is one trigger that could accelerate everything. If a federal enforcement body receives a direct court order requiring concrete action that conflicts with an executive interpretation, the abstract dispute becomes immediate. Imagine that moment: a court order on one desk, an executive directive on another, the same federal institution positioned between them. This is where the architecture of checks and balances faces strain, not in theory, but in execution. Because enforcement is not about speeches. It is about who signs, who carries out, and who complies. And if this continues to escalate, the next stage will not revolve around who is right. It will revolve around which branch can translate authority into action without breaking the constitutional framework. The system is moving into a stress test, not on paper, in practice. So where does this move next? In moments like this, institutions reveal themselves through signals, not speeches, not headlines. Signals. There are 6 indicators to watch. First, does the United States Department of Justice defend President Donald Trump's position in full without modification, or does it begin to adjust its language? A subtle shift in phrasing can signal strategic recalibration. A rigid defense signals escalation. That choice alone tells us whether alignment between the executive and its legal arm is tightening or softening. Second, does a lower federal court issue a specific enforcement order, not a general statement, a directive with operational detail that would convert abstract disagreement into actionable command? Third, does Congress convene emergency hearings? Oversight does not directly enforce a Supreme Court order, but it reshapes political incentives. Public testimony changes calculations inside every branch. Fourth, does the White House alter its communication strategy? If rhetoric moderates, that suggests room for institutional negotiation. If it intensifies, it hardens the frame. Fifth, do federal enforcement agencies signal neutrality? Silence can mean compliance with process. Public clarification can indicate strain. Sixth, does the Supreme Court issue supplemental explanation? An additional clarification from Chief Justice John Roberts could narrow ambiguity, or it could entrench the divide. Here is why these 6 signals matter. Each one tilts the balance between de-escalation and structural confrontation. Now consider the 3 plausible paths forward. Scenario 1, institutional cooling. The executive branch adjusts its actions to meet the compliance standard articulated by the court. The Department of Justice reframes its position accordingly. The lower courts never need to issue coercive orders. The temperature drops. The constitutional system absorbs the shock. This would reaffirm the supremacy of judicial interpretation without direct enforcement drama. But cooling requires concession. Even if framed as clarification, scenario 2, procedural escalation, a lower federal court issues a detailed enforcement directive. The Department of Justice faces a binary choice: fully comply with the judicial instruction or continue defending the executive interpretation. In this scenario, friction becomes visible. Every filing, every response deadline becomes consequential. The machinery of enforcement grinds forward step by step. And here is the line that matters. Once enforcement is specific, delay becomes riskier. Scenario 3, deeper constitutional crisis. The executive branch continues to reject the court's compliance standard. The judiciary continues to reject the executive's claim. Enforcement becomes uncertain. Federal actors are placed in ambiguous positions. The checks and balances framework enters territory without clear precedent. That does not automatically mean breakdown, but it does mean strain at a level rarely seen. Now widen the lens. On the legal axis, this moment could redefine the scope of the Supreme Court's authority to supervise implementation of its own orders. Does judicial power end at declaration, or does it extend into granular oversight of execution? On the national security axis, if the underlying order involves sensitive policy, delay could create operational gaps. Even uncertainty can alter planning cycles inside agencies. On the political axis, institutional polarization intensifies. When a president labels a judicial act a judicial coup and the court formally rejects executive compliance, the center narrows. On the electoral axis, public trust becomes a variable. Voters may not parse procedural nuance, but they respond to perceived instability between branches. On the geopolitical axis, allies and adversaries watch closely. The durability of American constitutional order has long been a strategic asset. Visible strain invites scrutiny. Here is the gravity drop. This is no longer about who wins a legal argument. It is about whether the system can enforce its own rules when the highest offices disagree. So the final constitutional questions come into focus. Where is the boundary of presidential authority when confronted with a definitive judicial ruling? Does the president retain interpretive space in defining compliance, or does the court's word bind in method as well as outcome? How much pressure can checks and balances absorb before friction becomes fracture? And in a system without a clear precedent for this exact configuration, does the constitutional framework possess enough internal correction to prevent either branch from claiming unilateral victory? The collision is still unfolding. The next move will not simply shape a case, it will test whether divided power can still coordinate itself under stress.